23-565, Hogan versus Southern Methodist University.
May it please the court, Mr. Furia will present argument for the appellant. The appellants have reserved 5 minutes for rebuttal.
May it please the court. We are here today on a certified question from the Fifth Circuit, which asks whether the PLPA, Pandemic Liability Protection Act, violates the Texas Constitution as applied to appellant Mr. Hogan's breach of contract claim against SMU.
So we don't have the unjust enrichment and conversion claims in front of us, just the breach of contract claim?
Correct.
What happened to those other two?
They were dismissed at the district court, and this is the only part of the case that was certified to this court. Appellant respectfully contends that this court should rule that the PLPA does, in fact, violate the Texas Constitution's prohibition on retroactive laws. Prior to the passage of the PLPA, in August of 2020, appellant filed a breach of contract lawsuit seeking damages against SMU. 10 months later, the PLPA came into effect and terminated his right to pursue damages against SMU.
Am I correct that this case is purely about the spring 2020 semester?
That's correct.
During that time period, were there government orders in effect prohibiting SMU from holding in-person class?
There were. So you are I'm sorry.
Yeah, so why aren't we arguing about some kind of impossibility defense as opposed to worrying about what the statute means?
We should be, but we didn't get that far. Because at the pleading stage, the court said the PLPA wipes this case off the map. So we never got into standard breach of contract defenses. But even
generally, there's a defense in a breach of contract case if performance has been rendered impossible by the government.
Correct.
So I wonder whether, as applied to this claim, all this statute is doing is saying, well, that kind of a defense is absolute. The legislature sort of ratifying the shutdown as applied to universities and saying, if that's why you canceled, then your impossibility defense essentially is rock solid and we're done.
Well, Your Honor, if the impossibility defense is all that the legislature was trying to do was take out and put it into law, there would be no compelling reason to have it applied retroactively, which is what's needed for
my question is, in this case, what else does this statute need to do other than sort of solidify the impossibility defense that is already in the common law?
Because the impossibility defense to a breach of contract claim, now this is a breach of contract claim, but this applies to any claim for damages against the university stemming from COVID-19. So even if it was just an unjust enrichment claim, which this well could be, if there was no contract, it would still be in effect. So this is not just an instance where the legislature took the breach of contract defense and turned it into law. It actually made it impossible for anyone to sue for damages. So it goes much further. This is a real legislative.
Right, but the certified question is about Mr. Hogan's breach of contract claim. It's specifically framed that way. That's the case that's in front of us, and that's a case about a time period in which, as I understand it, performance would have been illegal unless we're going to open this up to a discussion of the validity of the shutdown orders.
Well, and that's correct. And we're not just saying that they should have performed. What we're saying is when you take money that's supposed to go to, for example, fees for in-person services like health facilities, laboratories, libraries, athletic facilities, and then you don't actually run those facilities, you should have to give some of that money back. So this is a standard breach of contract claim.
This is not a case where you have, say, prepaid, say you're renting an apartment from the university and they end up shutting the apartment complex down at some point. I don't know if any university actually did this, but just assume with me that happens and you've prepaid your rent. In your view, would you be able to get the rent back for the months that you weren't able to live there? Say you prepaid 3 months of rent, you only got to stay there a month, they shut it down because of COVID.
That's not part of the facts here, but if that were the facts, I'd say yes, you do get your money back. When person A pays person B for services that aren't rendered, person A can ask for some of that money back. It's a pro rata refund, though, because there may have been, and look, there could be defenses. Maybe there were some costs involved, even if the apartment complex was actually shut down.
But we don't have to decide that in this case because we don't have any facts that are like that where there are services that were prepaid.
Exactly right. So, but in this case, we do have fees that were paid for laboratories, libraries, and things like that. and then they weren't actually available to the people who paid for them. So again,
It's a general fee, right?
yes, it's called the general fee or the student fee, but there were also some course-specific fees like laboratory fees for chemistry and biology classes
That were paid in this case?
that are part of the complaint. Mr. Hogan himself did not pay those, but remember, this is a class action complaint, so there are some facts and some allegations in the complaint that may not actually apply to him personally. But some of the students at SMU...
Has the certification decision been? No, not yet. So do we just look at his facts?
Yes, I would say so. Yes, sir. So, in this state, the Constitution says that no retroactive laws are allowed, but as the jurisprudence has developed, we have the Robinson test, which we look to determine if a law is unconstitutionally retroactive. The first prong asks that we look at whether settled interests were upended by the law, and here they were. Mr. Hogan had a settled expectation that he could sue SMU for breach of contract and obtain damages. And that's shown by the fact that he did it. He did it 10 months before the law went into effect. And SMU says that this is a questionable case or lacks merit, but as I just said, this is a pretty basic case. Services were paid for and not rendered. So we're not out on a limb here in any way, shape, or form. And also, if these types of claims were so meritless, and so something that these universities don't really need to worry about because they have no basis, then how is there a compelling reason for the legislature to come in and stop these cases from coming forward and actually going to verdict or judgment, right? If a claim is actually meritless, let it be dismissed the old-fashioned way. You don't need a statute to come in and take the place of a judge or jury.
But we have looked in other situations, not only under the retroactivity clause, but say under the open courts provision, and basically said if you're no worse off than you would have been under the common law, then there's no problem.
Well, correct, Your Honor. I guess the point I'm trying to make is it rings hollow when SMU says, on one hand, this law was actually needed to stop bankruptcies and all these other things that might have happened. But then at the same time, these cases are actually completely meritless. So how are a slew of meritless cases?
There's value in certainty, right?
Well, there is value in certainty, but we're talking about the need for a compelling public interest. I don't think certainty is a compelling public interest. This court may disagree. But remember, we have that Constitution we spoke about before. No retroactive laws. And this here is an exception to that, to the actual wording of the Constitution.
For other claims besides money damages or other remedies besides money damages that are conceivably available, are there not?
Well, in the initial complaint filed by Mr. Hogan, he was seeking money damages only.
You added declaratory and injunctive.
Right, so the amended complaint did add declaratory and injunctive relief, but we have to take a look at the timeline here because it's important, and that's the way we can look at this case pragmatically, right? When the PLPA became law, and when the amended complaint was filed, Mr. Hogan had already graduated. So he might have put in, counsel may have put in there a mention of declaratory relief, but as someone who was no longer a student, he had no ability to obtain declaratory or injunctive relief related to tuition. It just was never going to happen.
But what was the desired injunction going to say?
To stop SMU from charging the same tuition on campus for online learning that it would have if they were on campus.
That's sort of ship has sailed.
Oh yeah, the ship had sailed before that complaint, that amended complaint was drafted or filed.
But the amicus brief from Baylor points out that there's another one that could be sought, which is rescission.
Again, that's somewhat tongue-in-cheek novel. I don't see how rescission works here, especially in the case of fees. Right?
He gives back the college degree, they give back the fees.
Even if theoretically that could work, it wouldn't work on the fees aspect because those fees were paid to allow laboratories and facilities to operate. They never operated. There's no rescission that could possibly occur.
The rescission, I thought, would basically be to set the contract aside. So, like, okay, look, the fees were for running a lab wasn't running, so clearly the fees for the lab shouldn't be charged. This is the theory, at least. So you get those back. But on the other hand, the tuition, the fees were designed for you to get the degree. If we're setting aside a contract, it's only fair that he be stricken from the rules of SMU graduates and maybe comes back and does the semester some other time. That's what rescission would be. Was that an available remedy or not?
No, it wasn't. And what the amicus filers said in a footnote, if you notice, they said, by the way, if he asks for rescission, we'd say it's not available. So, you know, it's sort of a thought experiment, but it's not realistic. And it certainly wouldn't apply to the fees in the case.
Universities cancel classes in connection with weather events, snowstorms, hurricanes.
Correct.
Has there ever been a case that has recognized a cause of action for the cancellation of classes as opposed to something more concrete like the failure to award a degree? Before your case in your suit, is there any common law case that you're relying on to say, look, this is not a novel theory, this is something that has before resulted in a recovery for a litigant?
No, not that I can name for you here today, but I would say that the way we look at this case is that it's a breach of contract claim between someone paying for a service and someone who didn't provide the service. I'm sure there are many instances and examples of that. So, but the question of the strength of the claim would speak to whether there was a settled expectation here.
Right, and the extent of the impairment, perhaps.
Well, yeah, so here the extent of the impairment is entire, right? Because we have a claim for damages that 10 months later a law comes out and says, you can't have a claim for damages. That's all he was ever going to be able to get. This is, was, and always will be a claim for contract damages. The other thing that this court should keep in mind, as you mentioned in the Fire Protective Services case, is that the court looks at grace periods. There's no grace period here. In fact, this law applied to claims like Mr. Hogan's, which were already filed and being litigated for almost a year.
He filed in summer of
2020, August 2020.
August.
In state court, it was removed to federal
So
court.
if the legislature, March 2020 comes along, everything shuts down, and if the legislature had immediately passed the PLPA in June of 2020, would that still retroactively impair his contractual rights?
It would, because it would
He hadn't sued. So you would be making the same argument that the PLPA enacted in June of 2020 unconstitutionally retroactively impaired his right to sue for breach of contract, even though he hadn't sued yet.
correct. And the language that I take from Robinson is that it changes the rules of the game after it's already been played. That was the language from Robinson. I think it tells the tale pretty well, because even if he hadn't filed the claim, it was a contractual relationship that's now been turned on its head. He can no longer sue for damages. The only way he can actually enforce the contracts. But because he actually did file and the litigation was ongoing, and remember, this is an as-applied challenge, it makes it worse. It makes our claim stronger, because he was in the middle of litigating. And this would have been a complete termination of his claim up to the point of final judgment. I could have been in trial giving a closing argument in this case on June 14th, 2021, and the case goes away. That's legislative overreach. And that's what this court needs to look at, because we also look at the compelling public interest. And COVID was obviously a terrible thing, an emergency, something that we hadn't seen before. But it's in instances like this court really has to worry about legislative overreach, like what happened here.
I struggle to see how we can look at this outside of the context of the impossibility of performance created by the government orders. In response to that, they perform in a sort of a different way online. He still gets the diploma which is surely a large part of the value that he contracted for. You talked about the fees for the facilities. There are other expenses that they incurred due to the pandemic to rearrange their affairs and to do things differently. Maybe we could have a trial about whether they owe him a few $100 because there's some leftover money after they allocated his fees to other expenses that they had because of this extraordinary event. But at the end of the day, performance was rendered impossible. And the legislature just says, we're going to call all that a wash. But it's difficult for me to imagine that that's unconstitutional.
Well, it is, because those few $100 that each student might be owed, it matters. Remember, this is a class action. What's the purpose of class actions? It's to allow a bunch of people who have small amounts of damages to get together and actually obtain justice. So the fact that maybe it is a few hundred or a few $1,000s per student on the fees, that may be their damages, so it may be quite a bit more when aggregated.
They still have expenses associated with the things that those fees were going to be spent on, right? I mean,
they very well may, but we were never able to find out during this litigation whether they actually washed out or not. And if at the end of the day allowed to get it. This statute says you're not allowed to actually litigate a breach of contract claim for damages. It's not right. And I would point to something that
I tend to view this as the statutory imposition, it's a statutory ratification of the impossibility defense with maybe the very slight added content of we're just going to wash out these little questions about fees and how much money they spend. And it just seems so in line with the traditional impossibility defense, which is deeply rooted in the law, that I just, irrespective of the doctrine about the retroactivity clause, it's just very difficult for me to imagine this is something the legislature is powerless to do.
But again, I think it raises the question of why did this need to be done in a retroactive manner? Because remember, we're only here because this was applied retroactively. And if it wasn't done in a retroactive manner, perhaps it wouldn't be.
Because they would have had to have done it by January of 2020 for it to matter under your theory.
Well, no,
that's why it had to be retro. Because all in this case at least, all we care about is spring of 2020. And as you just said earlier, even if they had passed the law in June of 2020, it would have been too late. So they would have had to have done it before your client signed up for that semester.
Well, remember, this is a balancing test, right? So because of the facts as they stand, we argue that they balance in our favor, but there's nothing stopping the legislature from saying, we're going to give a 3-month grace period, and then claims that are filed after that are going to be barred. Would that technically be retroactive? Yes. It would be less offensive, and it would actually tilt the balance on this balancing test.
Any other questions?
I just have one, Chief. Does the issue about whether there's any money left at the end of the day, as Justice Blacklock mentioned, there may have been extraordinary expenses incurred to continue to provide instruction in a different way, and if those could be netted out against any expenses that were saved, and it's not clear that anything is left, doesn't that go to the extent of the impairment prong under Robinson? If it's not clear there is any impairment?
If this record showed the court that there were no damages to recover, surely there would be a question about the extent of the impairment. This record does not say that. So
Whose burden is that?
At this stage, well, we have the pleading that we've put together, and it doesn't say that there was the expenses washed out.
Right, but you're the one that's raising the argument that the statute is unconstitutional, right? So don't you have the burden?
We have the burden, but at the same time, we're at the pleading stage where the pleading is supposed to be taken as true. And that should not be changed by the fact that we're challenging the constitutionality of the statute.
Could you have asked for some discovery on that?
On the question of damages? We certainly could have, but I can tell you that we didn't receive that in the trial court. Now, there is an ongoing proceeding because the Fifth Circuit remanded the contract claim back to the trial court. So that may well come to pass at some point, but it's not in the record before us.
Any other questions? Thank you, Mr. Furia. We'll hear from the Appellees and Amicus.
May it please the court, Mr. Barnard will present argument for the Appellees. Mr. Davis will present argument for the Amicus. Mr. Barnard will open with the first 15 minutes.
Thank you, Mr. Chief Justice, and may it please the court. In March of 2020, in order to stop the spread of COVID-19, Governor Abbott issued executive orders that required entities all over Texas, including schools and universities like SMU, to stop in-person education. And as I think we talked about a minute ago, context matters. If SMU or other schools had failed to follow those executive orders, there would have been significant penalties. As a result, it's unsurprising that the Texas legislature stepped in the wake of these executive orders to try to protect schools as they tried to follow these executive orders and shift to online learning. In particular, the Texas legislature was concerned about this wave of COVID class actions that we are starting to see in Texas and around the country, and the fact that these COVID class actions could result in monetary judgments that would impair schools' ability to educate the citizens of Texas.
If the judgment that theoretically could happen, as I understood from your friend on the other side saying, it would be the wash, whether or not the very serious expenses that SMU was put to buying all these new cameras maybe new medical cleaning and all those things. Maybe it exceeded the amount per student that they had paid. If so, there would be no costs, and if there weren't, it would be a very small amount, but it would be amounts that weren't spent. So what would really be the devastation? I don't see where the bankruptcies and the carnage and all that would come from.
Well, again, these cases haven't been tried yet, and we don't have any kind of discovery at this point, I think, as was pointed out a minute ago. But the issue is there's the potential there for damages that could impair the schools. For example, you're talking about, if you're thinking about tuition, you're talking about the last, 6 to 8 weeks of the semester. And if this is a class action against a school like that, that could be, tens of millions of dollars. It could be a large amount. I understand the point you're making, which is if we're just talking about fees, and again, there hasn't been discovery on fees, and there's an issue about that was raised at the trial court in our answer about some of those fees have been refunded already. But there's the potential here, if you're talking about tuition. The other issue, too, is when the pandemic liability...
Before you turn to that, what is that potential? If the Furia is, I don't know if it's a stipulation or whatever, but if they're saying, look, if you ended up having to spend more or the same amount anyway, and for example, you probably had to continue to pay employees, maybe you had to continue to pay the same kind of insurance for things, I don't know. So all those expenses for that last 6 to 8 weeks may have exceeded it, but if it didn't, what's the real exposure other than an amount that you received that you didn't spend by definition?
Well, I think part of it is we didn't really know at that point when the Pandemic Liability Protection Act was passed in June of 2021. It's kind of hard to go back and remember what things were like there, but there's still uncertainty. We were looking at a second wave, Omicron is going to be a possibility, and so there was a lot of uncertainty at that time. And so I know that for purposes of this case, we're speaking right now about spring of 2020, but it could have been the issue where this is years that there is, students are online. We just didn't know at that point what was going to happen. And so
but I think maybe this case is quite a bit more interesting, more difficult if we were talking about a later period, right? And if it were not the governor's decision, but the school's decision to hold class, to provide this education in a way that's radically different from what were the expectations when the student paid for it and contracted for it. That would be a much closer question, I think, on retroactivity.
Sure. I think that's right, but I think the issue that we have here is the legislature is trying to protect schools that are following, as we've talked about before, these executive orders. That's the compelling public interest, because
because it's following the executive orders, would you agree that basically the effect of the act in this situation is similar to the common law impossibility defense?
Well, I think it could be the case. It's hard to tell if there was impossibility here or not, but that is obviously a defense that would have been raised if the case had become more mature. I think that kind of goes back to looking at what were the settled expectations of Mr. Hogan, and kind of going back to think, what was this case? At the time, we looked to when the Pandemic Liability Protection Act was passed, and at that point in June of 2021, this was a very novel claim. I think Justice Bland mentioned this earlier. It was a novel claim. Impossibility was going to potentially be implicated. Illegality could have been implicated. It was unclear what was going to happen with this. And that's one of the factors we look at when we look at this court tells us from the Robinson principles, you look at the nature of the right and the settled expectations.
If we'd been in 2021 and so after the act is passed and if students pay for in-person school, the school is ready to do in-person school, and then not because of government orders, but because of its own decision, the school decides, sorry, we're going to move online. Does the act protect the school in a case like that?
Well, I think that's an interesting question. I think that the act is focused on the pandemic emergency as part of the justification for this, but it also talked about the danger from financial harm that could occur to the school. And so it's not clear to me if there would still be educational harm if the school's making the decision. But in this case, as an as-applied challenge, we know the reason that the SMU and others were doing it was because of the governor's orders at this point.
But the statute had forbidden any recovery of tuition or fees in connection with the failure to award the degree, as opposed to cancellation of a class, program, or activity. Would that present a bigger problem?
I think it could. I think, and it kind of goes to the point here, which is we talked a little bit about these schools have fixed costs. They're paying for salaries. They're paying for facilities. But at the same time, the students are getting educated online, the best that the schools could do given the circumstances at the time. They're getting educated online. they're getting class credit, they're able to graduate. Mr. Hogan was able to graduate in this case because of that. And so I think in this situation, the students were getting some sort of value. It's different from the apartment hypothetical we talked about earlier, where there was like nothing being given because you've shut down the apartment for several months.
Are those the kinds of fees that are being refunded? You mentioned some fees are being refunded or were refunded.
Yes. I mean, again, that's a little bit outside the record, but we have footnotes in our briefing at the trial court about fees being refunded. That's right.
And those would generally fall within that category where it's prepaid stuff that you didn't end up getting because of the pandemic.
Exactly. And to some extent, people did pay fees and get certain benefits. Like, I think they went for the health administration.
Gym membership, maybe you can't go to the gym.
Membership, yeah, I'm sorry. Gym membership you couldn't, but like, for example, I think healthcare, they shifted to online healthcare for students. And so you may pay a fee for healthcare, but at the same time, you weren't getting it in person. They're now doing it through Zoom or what have you.
You may not be able to go to the dining hall.
For sure. And there were refunds for housing expenses and I think some of the meal plans.
One of the things Robinson tells us is that the absence of a grace period isn't dispositive, but could you address the fact here that that's one thing we consider, whether there's a grace period?
And I think this court in the Fire Protection Services said it's something you consider, but it's not required. Robinson says explicitly you don't need a grace period. I struggle a little bit on how a grace period would even work here exactly. I mean, he was able to bring his case, and in fact, after the Pandemic Liability Act was passed, he amended his complaint to add, like we talked about earlier, injunctive relief and declaratory relief. So, I mean, he was able to bring his case, and I think the statute kind of did what it was supposed to in that regard.
What would an injunction do for him?
Well, it's a great question. I mean, I think one of the things that you're looking at now is, is there a remedy available? Not whether he's going to succeed on that remedy or not. And as I just mentioned, he added injunctive relief and declaratory relief after the PLPA was passed. And so it's difficult to think of how that would work exactly. You'd have to ask my friend across the aisle what he meant by that as far as the timing. Maybe an injunction could have been brought in March of 2020 when the governor's orders went into effect. Maybe there's some sort of specific performance or declaratory relief where you can ask a school to press the pause button and let's just stop classes for 6 to 8 weeks until the pandemic passes and you're safe to kind of go back and then you can finish the in-person classes. But the point is, those are remedies that are still available. Even if you take away monetary damages, he still has these remedies. And it's not the viability of the remedy, it's the availability of the remedy. And here, in roughly 175 years of jurisprudence, this court has never tested the effectiveness of, or asked to look at the effectiveness of the remedy. It's just whether there's a remedy available.
So is rescission relevant in that sense?
I think rescission could apply. I think there's some issues with rescission on whether the Pandemic Liability Protection Act has language that says equitable monetary relief, and it's not clear to me if that would cover that or not. And obviously, if the purpose here is to protect the schools from large financial judgments, rescission would not help them in that regard. And
Hauer seems to take a different position on that in their amicus brief. They say a tuition refund would not be equitable monetary relief and compare it to back pay, but you don't agree with that?
I think it's an unsettled area of the law. It's very gray on whether that would be covered and whether that would fall under the definition there. But again, I think if you look at the overall issue of the statute, I guess there's a practical question too. Are people going to get a degree, get a job, and then try to rescind and like give the college degree back and still basically have their job and say, I just want my money? It seems like that's unlikely to occur. But I think if there was, if the school did have to return money, you're back to where you started, and that's the whole purpose of the Pandemic Liability Protection Act, is to protect these schools so they're not having this financial impairment that impacts their ability to educate the students in Texas.
Let me ask you another question about equitable monetary relief. So typically under a common law impossibility or illegality defense, if it's partial illegality or partial impossibility, then you try to apportion the contract. And so if one side is paid all the money, but then the factory burns down and you only deliver half the widgets, presumably you would have to give back half the money is generally the way that the Hornbooks talk about it. Would that be equitable monetary relief that you wouldn't have to give back in restitution in a case like this, or would you say no, we'd give back anything that hadn't been earned?
I guess the question is and it kind of goes back to what is the contract? Like, what was the requirement? Was it enough to do online education where you're getting credits and you're able to graduate? And that obviously goes to kind of the crux of the contract case. And I think it's important to look at Mr. Hogan's contract case in that regard to understand what he pled. When he first brought the lawsuit in August of 2020, he brought an implied contract. And then when he amended his federal complaint later, he continued to have that implied contract. It wasn't until he got to the Fifth Circuit that he said that there was an express contract. And in that express contract, he's now using these two words, educational purposes, to say that that is a promise for in-person learning. But those two words, educational purposes, don't even occur in either one of his two pleadings. And so his expectations are very unsettled. He doesn't have reasonable expectations because he doesn't even know what his contract claim is. It shifted from starting off as an implied contract claim and shifting to an express contract claim. Now it's these two words. And so to answer your question, Justice Busby, was there is there something else to get back, or has SMU complied with what the agreement was, which is we educated you, we gave you a degree, you learned what you were supposed to, and there was no requirement, there was no express contractual promise for in-person learning.
It feels like we're arguing an appeal from a summary judgment on the merits here, impossibility defense. He really got the value he wanted. We really had to incur the expenses anyway, and that those defenses and theories are all part of the construct of contract law that existed when the two of you entered into the contract. All well and good, you knew what you were getting into, and contract law is going to apply if there's a problem. But isn't the issue here whether the legislature can come back at some time in the future and say, forget all that stuff, impossibility defense, calculation of damages, causation, forget all that, you just can't sue. Retroactively, why doesn't that destroy a vested right that had value, that, I'm confused why we're spending so much time today arguing the merits.
But part of the issue on that is under the Robinson factors, and when you look at like United Carbide, one of the issues is the nature of the right, and to determine the nature of the right, you look at the predictability.
Yeah, but not the value of the right. The nature of the right is a right to enforce your contract. And,
right.
For hundreds of years, that's been the right, and that's a vested right that both of you had in January of 2020. Right. Enforce your contract unless it's impossible, unless there's a credit due. That's the nature of the right, and that's certainly a valuable right, but whether it was impossible to comply because of a governor's order or because of a virus on campus, that's not the nature of the right.
Would it go to the extent of the impairment?
It could go to the extent of the impairment. It also goes to the predictability, which is the nature of the right. And so I respectfully, Justice Wood, I think the issue is one of the factors that Robinson tells us to look at is this predictability. We see that in the Union Carbide case. And so it may sound kind of like a summary judgment, but you're looking to see what are we taking away. And I think it's important to contrast this with Robinson, where they had a partial motion for summary judgment.
You're taking away the petitioner's right to argue that the impossibility defense doesn't apply, right?
I think it's a factor that the courts look at, but I think you're trying to understand how is it going to go forward. And maybe there is some sort of collapse between the impossibility and the predictability analysis here. But again, this is one of the factors that we've seen and that the court just affirmed last year in the Fire Protection Services case. And then the last thing I'd like to touch on very briefly is just the compelling public interest here. There is, in 4C of Senate Bill 6, there's discussion where the legislature was trying to be very careful to craft this to follow the prior decisions of this court. And it looked at the public interest, the compelling public interest, which was, again, to understand that Texas needs higher education schools like SMU to educate its citizens.
Any other questions? Thank you, Mr. Barnard.
Thank you.
Mr. Davis, we'll hear from the state.
Thank you, Mr. Chief Justice, and may it please the court. Just to pick up on that last point, the legislative findings which appear in Section 4C of the bill, I think what we see here is the legislature accounting for and responding to both other branches of government. And Justice Blacklock, you touched on this a bit. You're focusing on the executive order. The legislature is recognizing that executive order requiring schools to shut down and stay shut down could give rise to significant amounts of litigation. And it's responding to this court's precedent by using the words that this court uses when justifying the retroactive effect of the legislation. It talks about impairment of settled expectations and a compelling public purpose and the emergency that justifies the retroactive legislation. It's doing exactly what this court told it to do. And it's in contrast to Robinson, where, of course, there were no findings at all. And what we could see from the legislative record suggested an effort to help just one company. We're at the other end of the spectrum here. On the second point, the second prong of Robinson, it looks to the nature of the prior right, and there's been some questions along those lines. Mr. Hogan focuses on settled expectations. That's correct, but not complete. The phrase is reasonable settled expectations. That's emphasized several times in Robinson. And it's not reasonable to think that the legislature wouldn't come in and account for the governor's executive orders and the pandemic here. Also, when we're talking about a claim, what kind of claim is it at issue? It's not enough to say in the abstract a breach of contract claim is well settled. That's too high of a level of generality. The court looks to the specific type of claim. And here we're talking about a claim that's based on two words in a student agreement that don't say anything about in-person instruction. Again, there's a stark contrast to Robinson, where the claim at issue there, a specific asbestos claim, had resulted in judgment for plaintiffs in several other contexts, and in fact had been the subject of a successful motion for summary judgment for the plaintiffs in that case. And that flows into the third prong of Robinson. What's being taken away here? If what's being taken away is a right that has no weight or very little weight, the legislature is taking away nothing or very little, and that, again, is in favor of constitutionality. As to remedy, there's been some discussion about that today, too. The analysis looks to whether the legislature left some remedy on the table. It might not be the remedy the plaintiff wants, but it's not extinguishing all remedy. And there are plenty of cases from this court saying if you're not extinguishing all remedy, it's not a retroactivity problem. Mr. Hogan,
What's the remedy that?
Well, I think if Mr. Hogan could have sued earlier and tried to get an injunction or specific performance to allow him to take his classes in person. And just because he didn't do that on time doesn't render the statute.
When he sued, there had been no elimination of his right to damages. So it seems kind of tricky to say, well, damages are going to be taken away. You should have fast forward until the next legislative session, and you should bring other claims that maybe the legislature would choose to leave intact. That's requiring a time machine.
Well, the point is that at the time that he was facing the conduct that he didn't like, he had a remedy that he could have pursued. The legislature has never taken that away, and the court's precedent again.
Wouldn't the better analysis be at the time they took the rights away, did they take away all the remedies?
That would be another way of looking at it.
And didn't they? I mean, but what remedy at the time that this act was done? What remedy did people like Mr. Hogan have? Well, that it didn't take away.
Right. I guess I would push back on that a little bit in saying that the legislature didn't extinguish anything but damages and equitable monetary relief. There were things that Mr. Hogan could have done earlier. As the Baylor Amicus brief is noted, rescission possibly is another remedy that could apply here. The point being that there are no cases from this court that say just taking away some of the remedies can equal an unconstitutionally retroactive law.
This statute, the provision that we're focused on, applies only to educational institutions. So it's not the Robinson problem of just one company, but is it a problem of just one industry?
Well, no, Your Honor, because we're talking about Section 148.004B. That's the only provision that's been challenged. But that applies to everything from preschools all the way up to graduate school, public and private. It's not.
Was there no one else in the economy or the states that might be subject to litigation relating to promises made contracts that were formed, that were destabilized by the executive branch's early pandemic orders?
Well, the broader statute also protects different segments of the economy.
Yeah, so is there anything that's not protected, or is this pretty wide-ranging? I guess this one is just educational, but what I'm asking is, can we say that it's really everything, or are there just some chosen?
I guess I would have to look back at the rest of the statute, Your Honor, but it seems like a pretty broad-based protection that the legislature is.
Economy law, basically.
Exactly.
Any other questions? Thank you, Mr. Davis. Mr. Furia, you have 5 minutes.
Thank you, Your Honor. Justice Blacklock, I'd like to address the concern you raised earlier about the impossibility defense, because it's a good question. But this statute is not a codification of the impossibility defense because it goes so much further. Normally, restitution under the principles of unjust enrichment is available if a contract is deemed impossible. But this statute says not only can you not get damages, you can't get equitable damages, which would rule out restitution. So this goes way beyond the situation at hand here. Now, this is not an unjust enrichment case right now because the court found that there is a contract, but ultimately, during the course of the litigation, if it's determined that impossibility is a viable defense and it was impossible to comply with the contract, then Mr. Hogan would have viable claims for restitution. But this statute says he can't do that. So it goes way beyond impossibility alone.
Not necessarily different, though, from what it would be at common law, because if I remember correctly, the cases in the Horn books talk about damages that you can get back for impossibility, really depending on whether the contract is divisible or not. And so if it's not clear to me how this contract would be divisible necessarily, and then how you would apportion the restitution. And so if could you really get restitution in a case of impossibility if the performance is not divisible?
Well, yes, Your Honor. My understanding of the law as it stands is that when a contract is determined to be impossible and you can't recover on the breach of contract theory, you can look at whether restitution, and now you're looking at equitable principles, is
right, but it's only impossible in part, right? Because he went to school in person for a while during that semester, right? Through
Correct.
March? Okay. So how is that, how would you put a value on, 2 months of in-person versus remote education?
And we've only ever been asking, though, for a pro rata reduction of what he's paying. So we're asking for part of that amount back, and it can be done in a number of ways. It can be done by literally dividing the number of weeks where he received the services versus where he didn't. And also in these cases, very frequently, we have expert witnesses who come in and perform these complicated analyses. But yeah, certainly this is a case where we could put on before a judge or jury a case and explain that there's a certain amount that he should get back if a restitution theory was allowed. But again, this statute says we can't do that either. So it's not just damages, it's also equitable damages.
I'm not sure Baylor agrees with you about that, because they said that refund based on rescission would not be equitable monetary relief. So maybe restitution wouldn't be either. I don't know.
I don't know what equitable relief, monetary relief is, if
sure
it's
I
not
either.
restitution, giving back someone money under an unjust enrichment theory. That's the definition of equitable monetary relief, at least from my perspective. So we disagree with Baylor's position there. And then I would also just like to go back to just the larger question, which is about the construction of this portion of the Texas Constitution. Justice Blacklock, you actually raised this issue during the Fire Protective Services oral argument. You said something along the lines, I'm paraphrasing, that, hey, this Constitution says no retroactive laws. So now, that means the Robinson balancing test is actually an exception, okay? And every time this court allows a retroactive law to go on the books in a new set of facts, that exception is being expanded. And here, this would be a huge expansion, because you'd be saying the legislature can actually come in and say an already filed breach of contract claim for damages can just be terminated. So this court should ask itself whether it wants to go down that road and take that step away from a textualist interpretation of the Constitution. And again, we would ask that during the analysis that this court performs, and keep in mind, there is a strong presumption against retroactivity. So it may indeed be my burden to demonstrate that the law is unconstitutional, but there is a strong presumption that rests in my favor in this analysis. If there are no other questions?
Any other questions? Thank you, Mr. Furia.
Thank you.
Case is submitted. That concludes the arguments set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable Supreme Court of Texas now stands adjourned.